Just when you thought the elections couldn't get any weirder, in 2016 again, we have some last minute changes for what's going to be on the ballot. This time it's in Arkansas, where I just recently did a story about how the initiative number 6 was safe. um, I think 7 was still, there was still a couple of areas of contention at the time. And, well, the Supreme Court has finally ruled. And I guess, unlike Michigan, when they said that, well, if the Supreme Court changed the mind on what happened in Michigan, they wouldn't have had time to change the ballots and all that stuff. I don't think they even had time to change ballots here in Arkansas, but we'll get to that. But the Supreme Court struck down number 7 because they basically found that the supporters did not gather enough qualified signatures. The court disallowed more than 12,000 signatures, leaving 65,412 valid signatures, and that was just 2,465 short of the required number. This might sound familiar because the same thing happened in Missouri and the same thing happened in Oklahoma. So the powers that be, I guess you would call it, have spoken again. And you'll start to see why here in a minute. So for the petitioners, they listed 5 reasons on their opinion as to why the signatures didn't count. They said that some of the petition gatherers did not comply with Arkansas laws on who can be a canvasser. The signatures did not include an address or include only a P.O. box address. The canvasser verified the petition before the voter signed it. The canvasser checked an improper box. Canvassers did not specifically witness the signatures. So if this is all true, it just sounds like some sloppy canvassing and a bad campaign. But then again, I've seen this kind of scrutiny on these very same points in these other areas where this was a thing. And so the ruling comes even after early voting had begun already on Monday in Arkansas for the general election for the 2016 elections. So basically the ballots went out, and I believe both of these questions were on for the early voters, and maybe someone voted for it or against it, and then they just found out today that that vote didn't count because 7 didn't actually make the ballot. Arkansas for Compassionate Care said Thursday that it'll fight the decision by the state Supreme Court to disqualify Issue 7. It's kind of hard to see how that's going to happen because the Supreme Court's decision took effect immediately. And I mean, come on, the election's only a little over a week away. If it's already on the ballot, they basically can just say yes or no, and I guess if they got their day in court, they could actually do something like that. But anyway, so 4 years ago, Arkansas voters narrowly rejected a medical marijuana proposal. And back then, I think the contention was some of the things that were on the one that got disqualified this time. Medical marijuana had some more obstacles this time around, as the Republican governor, Asa Hutchinson, who used to be the head of the Drug Enforcement Administration, has spoken out against the measures, both measures actually. A coalition of the state's most powerful lobbying groups, including the State Chamber of Commerce and the Arkansas Farm Bureau, have also been campaigning against both measures. The state's Democratic Party isn't much better at this. Their platform includes general support for legalizing medical marijuana, but doesn't actually say anything about the 2 ballot measures. The state's Democratic nominee for U.S. Senate, former federal prosecutor Connor Eldridge, has said he supports developing a reasonable medical marijuana program nationally and in Arkansas, although he hasn't weighed in on either of the proposals. So let's get into what are the differences between Issue 6 and 7. Issue 6 is an initiated constitutional amendment known as the Arkansas Medical Marijuana Amendment, As the measure is an amendment, the Arkansas legislature would not be allowed to make medical marijuana illegal again without voter approval. Issue 7 was initiated state statute known as the Arkansas Medical Cannabis Act. As the measure was a statute, the Arkansas legislature would have been permitted to make medical marijuana illegal again with a 2/3 supermajority vote in each legislative chamber. So why are there two measures? Prior to the October 27th, 2016 Supreme Court ruling in Benka versus Martin that struck Issue 7 from the ballot, there was two initiatives designed to legalize medical marijuana on the Arkansas ballot. While there was a number of differences between the two, one difference in particular led the measures sponsors to propose separate initiatives. The difference was what was called the Grow Your Own provision. Issue 7 would have allowed some patients to grow marijuana for medical use. Issue 6 would not. David Couch, sponsor of Issue 6, worked for Issue 7's sponsor, Arkansas for Compassionate Care, in 2012 when the group's Issue 5 was defeated. Couch believes the major reason for the 2012 defeat was the Grow Your Own provision. Melissa Fouts, director of Arkansas for Compassionate Care, asked Couch to drop his initiative. She pleaded, "Please do not place thousands of sick and dying Arkansans' future in jeopardy. Patients need safe and legal access to cannabis, and if you continue, we risk losing the best chance we've ever had. Placing two initiatives on the ballot will cause both to fail." So what's the differences? Now, when you look at the differences, you'll see that Issue 7, the one that got struck down, was the more kinder, gentler, more decriminalizing, and more compassionate one, as you'll see really quick. All right, so Issue 6 versus 7, the changes to the law. 6 would amend. 6 was an amendment to the Constitution. Wait a minute. Yeah, and 7 was just adding a chapter to the Arkansas Code Title 20. When it comes to patient use, qualifying conditions, there was 17 on number 6 and 56 on 7. That's the major difference. Patient ID cards, renewal fees, grow your own provision. On 6, you do not get to grow your own. On 7, if you live 20 miles or more from a dispensary, you're allowed to grow marijuana. Both of them have like a 2.5 ounce every 2 week kind of a provision on the amount distributed. On 6, patients can purchase at any dispensary, and on 7, patients could purchase at a designated dispensary. So there's some trade-offs on 7. There's a couple things like that I noticed that were a little bit weird, like 6 was a little kinder on. Well, anyway, we'll go on. Patient choice of dispensary. And then we have college campuses. On 6, you're permitted or prohibited to use it on college campus, but 7 didn't have any such prohibition. Revenue allocation. Now the allocation basically says where the money goes, and we got just a bunch of stuff that goes to. Both of them have different things. Now the number 7 that got shot down had a provision in it to give remaining revenue to provide low-income people with medical cannabis. Now, I thought that was pretty good. Let me see. Local prohibition. On 6, voters can prohibit dispensaries and facilities in local communities. On 7, no provision for such local prohibition was there. Number of dispensaries weren't a whole lot different. On 6, it was between 20 and 40 in the state, but never more than 4 in any one county. And on 7, 1 dispensary for every 20 pharmacies, or about 39 dispensaries at the time of implementation. So then the number 6 had no requirements for dispensaries to be a nonprofit, whereas number 7 required dispensaries to operate on a not-for-profit basis. Now, I don't know if that was just some kind of thing that they wrote to appease somebody or whatever, but I don't see that being a big deal. 6 does not require marijuana testing labs. 7 does. 6, owners must be Arkansas residents. 7, the dispensary owners did not have to be residents. 6, disqualified anybody with any felony conviction related to violence or a violation of a controlled substances law within the past 10 years. 7 had any felony conviction would disqualify you from working in marijuana field. Dispensary advertising restrictions. Department of Health can regulate advertising on 6, and on 7 no regulation of advertisements. Alright, on qualifying conditions. Now I think this is important, so I'm gonna run down the list, and I'm gonna butcher some of the names of some of these conditions. I'm sorry ahead of time, but I'm gonna run through the list because I think this is important. Now the first list qualifies on both 6 and 7, so these are all still qualifications for medical marijuana in Arkansas if 6 passes. So you have Alzheimer's disease, ALS, arthritis, cancer, Crohn's disease, fibromyalgia, glaucoma, hepatitis C, positive status for HIV and or AIDS, PTSD, Tourette's syndrome, ulcerative colitis, chronic or debilitating diseases that produces wasting syndrome or cachexia, these are all chronic or debilitating diseases that produces, and you have peripheral neuropathy, intractable pain, severe nausea, seizures, severe and persistent muscle spasms, and then finally any other medical condition and treatment approved by the Arkansas Department of Health. And then the ones that are not going to be available for voters to vote on are not going to be on the list. It's a long list, and after I read it, I'm probably going to run out of time. So just remember that this sucks that none of these conditions will be available for medical marijuana if even 6 passes. So let's go. Darkham's disease, anorexia, Arnold-Chiari malformation, asthma, ADD and ADHD, autism, bipolar disorder, bulimia, causalgenia, chronic inflammatory CIDP, chronic insomnia, chronic obstructive pulmonary disease, COPD, complex regional pain syndrome, types 1 and 2, dystonia, emphysema, fiber dysplasia, general anxiety disorder, hydrocephalus, hydromyelin, I'm murdering them, I'm sorry, lupus, migraines, Parkinson's disease, PLS, post-concussion syndrome, RSD, residual limb and phantom pain, restless leg syndrome, SCA, spinal cord injury and disease, including both are not limited to traumatic brain injury is another one. Sorry about the ones I had to leave off the list, and the ones that I totally mispronounced, like whoa. So it's pretty obvious that the home grow and the extended list were the killers. So at least they get to vote for something, and I guess we'll just have to wait and see where it goes from there if it does pass. And that's all from Arkansas.